Hello and welcome to our new series on AI governance brought to you by the UCLA Law Review and the UCLA Institute for Technology Law and Policy. My name is Michael Karnikolas. I'm the Executive Director of the Institute for Technology Law and Policy. I will begin by acknowledging UCLA's presence on the traditional, ancestral, and unceded territory of the Gabrielino Tonga people. Today's event kicks off a slate of programming, a slate of ITLP programming related to AI governance. And that includes a new essay series in the UCLA Law Review discourse featuring comparative perspectives on this challenge. We are delighted to be joined by three of the authors from this series today. Alicia Solow-Niederman is an associate professor of law at the University of Iowa. Dr. Teresa Scassa is the Canada Research Chair in Information Law and Policy at the University of Ottawa Faculty of Law. Margot Kaminski is an associate professor at the University of Colorado Law School and the director of the Privacy Initiative at Silicon Flatirons. And our moderator today is Benjamin Falley, an editor with the UCLA Law Review Discourse and a JD candidate here at UCLA. We are hoping to set aside some time at the end for audience questions. So please place your interventions, questions, comments into the chat as they come up. I'm excited for the conversation. Benjamin, I'll pass it over to you.
Awesome. Thank you so much. And thank you again for everyone for joining us today. To start off, Professor Solow-Niederman, I was wondering if you could briefly introduce some of the challenges that are inherent in creating standards for AI governance.
Sure. And it ties into my contribution for the essay series as well. So I think when we consider AI standards as governance tools, one major issue that I see is the framing of the problem space itself, the role that we're expecting standards to play as governance tools, and our unexamined assumptions about these tools that we might not be thinking about. So my contribution asks, the title is, Can AI Standards Have Politics? Spoiler there is obviously they literally can, but I argue that taking their politics seriously will undercut their utility as consistent governance tools that can be diffused across distinct contexts. And so in the AI governance conversation, I worry that we turn to standards as a seemingly neutral objective tool. The ISO's International Standards Organization's definition is a standard is a formula that describes the best way of doing something. So we might naturally pull on a standard as a way to address a problem like bias or fairness and on transparency, trying to provide guardrails for public and private deployment and diffusion. And I worry that that can be a techno-solutionist mindset because standards, have to be created. And they have to be created by people who sit within institutions who face particular social, political, and economic pressures and respond to particular constituencies or not. And so by definition, they cannot be neutral tools. So I think that I see that, I could say lots more there, but I see that as a major challenge that we're not grappling with the inherently political and constructed nature of standards in many AI standards conversations. A standard for, say, fair AI as development is not self-defining. It can't be neutral because it has to channel a particular socioeconomic, socio-technical commitment to fairness as it is understood by the public and or the private actor creating that standard. And so returning to your question, a major challenge for creating standards that govern AI systems is how do we account for these politics? So I would reframe the question to think about that specific political economy from which a proposed set of AI standards is emerging. For one, I think it's useful to consider what happens in a nation state where there is public backing for standards versus where there's not, and to think through how market forces might be affecting standards development and diffusion in both situations. That's not academic. Just today, we see the EU moving forward with proposed regulations in the EU AI Act, setting forth essential requirements that apply to high-risk AI systems. Under the AI Act, AI providers are presumed to conform with these essential requirements if they comply with standards that are developed by two private standard-setting bodies. So in other words, we have a statute to regulate AI with the operationalization of key provisions being channeled through private standard-setting organizations. And we have markets factoring in insofar as the EU is hoping that its early movement on AI governance and economic power leads transnational firms to adopt its compliance benchmarks across all markets. So there we have just a bevy of issues concerning how representative these standards are of the public interest, which normative decisions they reflect, whose perspectives are or are not included, and whether it's even proper to disseminate these standards to other geopolitical contexts based on whether or not there's market uptake. And I just think we can't confront these questions honestly and earnestly unless we let go of the myth that standards are neutral. I should note too that it's just as thorny when there's not a public actor who's explicitly pushing to enshrine AI standards in national law. So take the United States and think of the many, many private firms that are selling AI tools to local, state, and federal government agencies. If a firm commits to have AI systems that are trustworthy or safe or respectful of privacy, then it's right now determining what that concept means and requires internally through its own procedures. It's de facto setting AI standards for the tools that it offers. And already, if that's embedded in the administrative processes of public actors, say to determine unemployment insurance or welfare benefits or many, many other cases, then it's diffusing those internally set AI standards and entrenching them in government itself. So a central challenge is how to contend with these politics of standards creation, recognizing that it reflects particular institutional standard settings and pressures, yet also realizing that tailoring standards to reflect these questions of political economy is going to make it harder to rely on them as stable tools of AI governance.
Thank you so much for that. That kind of leads nicely into our next question. Professor Kaminski, could you please introduce the role of stakeholders in AI governance in answering some of the questions that Professor Solow-Niederman raised?
Sure. I'm going to actually take a zoom out for a second and talk about, situate where these conversations are happening. So for those of you in the audience who might not be familiar yet with the moves in AI governance, the various attempts to govern artificial intelligence or algorithmic decision-making, both on the EU side of the Atlantic and in the US side of the Atlantic, have largely focused around risk regulation through the form of something called an impact assessment. So an impact assessment basically tasks the user of an AI system, sometimes the developer of an AI system, with risk mitigation that involves trying to figure out what kinds of harms is this particular system going to cause, and what kinds of mitigation can be used to get to what is considered to be a less risky enough level of risk that such systems can be used on the general population or specific, relevant to my talk today, on a particular impacted population. So this form of regulation, this delegated risk regulation through impact assessments, basically makes some assumptions about how good governance works and doesn't really cover all of its bases in terms of trying to make sure that companies or governments that are using AI systems don't basically rubber stamp them and say, go through an empty, meaningless compliance exercise to ensure that the systems look like they're safe and they've gone through this checklist when they actually haven't done much at all. When you look at the style of regulation in this space, so Alicia has spoken to, or Professor Solow-Niederman has spoken to one aspect of it, which is to delegate decision-making in the form of figuring out how risky is risky, or what's a good process for mitigating risk to standard setting organizations. You see that there's a lot of delegation from top-down regulation to some form of third party. So Professor Solow-Niederman talked about turning to a standard setting organization, which is often a technical organization or a technical organization with multi-stakeholder input. And I'm talking about a different form of delegation to a third party, which is delegation to those individuals and those communities that are themselves impacted by the ultimate use of the algorithm or the AI. And the first point that I make, both in this essay and in a larger piece that I'm currently writing with Gianclaudio Malgieri, my favorite Italian co-author, is that there's this noticeable move on both sides of the Atlantic and in multiple different regulatory instruments, from AI law to data protection law to sector-specific data privacy laws, including in my own state of Colorado, to trying to involve impacted communities and impacted individuals in the ex-ante risk regulation of AI systems. So you'll see laws that will say, in the particular impact assessment process, you have to go out, seek out either members of an impacted community, sometimes described as members of an impacted marginalized community or marginalized populations, or the representatives, to both try to get a sense of what exactly is the harm that we're trying to mitigate and when have we mitigated that harm enough. Now, this makes sense if you're thinking about this all as being a process of risk mitigation that's delegating to companies. We don't want companies to just go through a rubber stamping process. And we want to have some other form of input from the people who will actually be affected by this, who won't necessarily be able to affect standard setting processes at these multi-stakeholder institutions that Professor Solow-Niederman describes. The other reasons we can think of for these calls and these answers of stakeholder participation in these new laws include echoes of the racial justice movement, which calls for decentralizing control over police departments and policing policies and returning control to the communities that are actually directly impacted by these policies and practices. We also see a significant reflection of an area of regulatory theory that I have written about and Professor Solow-Niederman has written about, called collaborative governance, which says that for delegation to private companies to work effectively as governance, you have to involve third parties or there won't be accountability. So for a number of these reasons and others, we see this move to stakeholder participation. And one more that I wanted to emphasize is coming out of the computer science literature, particularly literature on human-computer interactions and interface design. There are calls for participatory design, which means designing systems in conversation, again, with the communities impacted by and using them. So for all these reasons, we see a turn to stakeholder participation. And the obvious next question is, can it actually work? And if you come into this with a great deal of skepticism about power and the ways in which companies that are regulated can co-opt their own regulations to effectively just do what they want to do anyway, then the answer is going to be no, because the fear is you bring people in as representatives from a marginalized community or population, you go through your checkboxing exercise. It involves talking to these people. You don't give them any meaningful power or any veto over whether a particular technology gets built or used. And then it just becomes window dressing. However, there are many different ways in which regulators can structure these interventions. And I guess the point of the brief essay that I have in this collection is to say, don't give up on them yet. They're definitely necessary and certainly not sufficient. You have to have stakeholder participation alongside many other forms of accountability. But this is a way or a hook for regulators and for those impacted by algorithms to get input into and control over the use of these systems, which a solely privatized impact assessment process does not itself allow. So I'll leave room for questions afterwards. Thank you, Ben.
Awesome. Thank you so much. And then Professor Scassa, I was wondering if you could talk a little bit about the intersection of AI governance and sovereignty, both at the level of the nation state and maybe how AI governance is challenging some traditional notions of sovereignty.
Yeah, thanks very much. When I was invited to do this essay, I thought I would kind of jump in with both feet and tackle something that had been kind of I've been mulling over in the back of my mind for some time now. And I had noticed over the last few years, the growing use of the term sovereignty in a variety of different contexts and by a variety of different actors in the tech regulation space, and in particular in relation to data and artificial intelligence. And it interested me, and I'd always thought, well, I'm going to have to explore this more. It interested me in part because we have these discussions in Canada that framed in terms of federalism and who's responsible, whether it's federal or in our case, provincial governments. In the US, it would be federal or state governments, but also in terms of the emerging Indigenous data sovereignty movement. And so I thought, well, I'm going to write about sovereignty and AI. And it's certainly the case that you see a number of different types of arguments or claims related to sovereignty or issues that emerge relating to sovereignty. For a number of years now, people have been writing about digital sovereignty and issues about what it means for a nation to be sovereign in the digital context. It can mean, control over critical data. It can mean the right to access data about one's citizens that might be in the hands of offshore companies. It can mean the need to develop one's own digital policies and digital laws in order to assert greater power and control. So digital sovereignty has certainly become a growing issue. We see this tension that I've already mentioned between we see tension between national and international governance of issues. And so sometimes digital sovereignty comes into play, or the concept of sovereignty comes into play in thinking about whether nations should be developing their own policies or whether we need international governance. And if we're going to have international governance, what level of or what types of sovereignty do nation states have to give up in order to conform to international norms that might be developed? Subnational sovereignties interest me quite a lot because because Canada is a federal state, and there have been some really interesting and challenging clashes around the jurisdiction as between the federal and state levels to regulate different aspects of artificial intelligence and different issues within the digital context. And so there and I really think federal states are tremendously interesting in this space. You see unitary states moving fairly quickly on AI policy and AI governance, certainly much more quickly than federal states. So the UK, for example, moves relatively quickly. France has moved very quickly. So you do see a fairly quick movement and coherent movement in unitary states. Federal states tend to be much slower. And I find that slowness interesting because I think it is in part because of the nature of a federal state and the challenges of managing what are essentially two separate levels of government, each of which is sovereign within its own sphere. So that's another dimension. And of course, I mentioned earlier the Indigenous data sovereignty movement, which has now growing links to AI governance. And sovereignty in that context, of course, is used as a form of is a reference to self-determination and what is required for what we call in Canada First Nations or other Indigenous communities to become sovereign and to move towards self-determination and in the digital context. And so there are, and this is an international movement, and we're seeing, I think, some really interesting ideas and concepts around sovereignty and digital and data sovereignty coming from Indigenous peoples. We're also seeing claims to group or collective rights in the digital sphere. So some of you may have heard of the concept of group privacy. And although that's not generally framed in terms of sovereignty, I think it's interesting to think about the underlying the claims to group privacy, this emerging idea that I think you see in other digital contexts as well, that communities, collectives, groups have interests that need to be attended to. And so I think this is another area. We also see sovereignty used with respect to individuals. And this is the one where I have more problems. And I mean, you see it in claims that individuals own their own data and data ownership claims, which are, I think, closer to property claims than to true sovereignty claims. But in any event, you see these kinds of assertions. And I think, again, it's an assertion of a desire to have some sort of control or greater level or degree of control. And so I think running through all of these is a concept of sovereignty, which is not so much the Westphalian concept of sovereignty, but a claim to some sort of right to govern or right to participate in government of these very pressing digital issues that we're facing. So my essay really explores these different dimensions of sovereignty and how these claims are emerging. And I do think it's particularly interesting to see their emergence within the digital context, perhaps in part because it's a context in which is so disruptive that it's disrupting ways in which people think of themselves or their communities and how they understand their rights or powers, or maybe it's encouraging those types of claims. But it may also be simply a reflection of the concerns over powerlessness, loss of control, and need to assert control and need to assert governance. So I'll stop there, and certainly happy to talk about this more. And I'm sure and many of you also have interesting ideas and thoughts about this.
Thank you, Professor. And then so these next questions I'm going to sort of open up to the panel. So feel free to chime in and engage with the question as you are able to, or think would be interesting for sort of the discussion that we're having. And I think maybe a good place to start would be, one approach to AI governance would be at the level of hard law regulation. And different states have different approaches to this. And I would be curious to hear a comparison of how the EU is approaching this with the EU AI Act with the United States or Canada.
I'm happy to jump in. So the United States does not have hard law on artificial intelligence. Instead, Congress told a federal agency, the NTIA, to go out and make some guidance through a multi-stakeholder process. So the NTIA put together, through this multi-stakeholder process over the last few years, the AI risk management framework. And the most intriguing thing about it, I think, is that it looks an awful lot like what the EU AI Act is putting in place as hard law. So I mentioned earlier this process of risk mitigation as being a common ground of AI law established across the Atlantic and in other jurisdictions as well. And I think hard law is a misnomer. It is top down in the sense that you have agencies that will be monitoring for failures to comply and will be enforcing it. But it is softer law in the sense that it does a lot of delegation to private entities or government entities that are developing and using these systems to basically monitor themselves. So even in the places with the hardest of hard AI law, you still have soft hard law in the sense that there is a lot of reliance on guidance and delegation and the standard setting processes that Professor Solow-Niederman referenced.
Yeah. Oh, go ahead.
No, I'm defer to you. I want to hear your perspective on Canada. I was going to make a different point.
Okay. Yeah, I was just going to say that in Canada, right now we have a bill before Parliament, and part of that bill is to enact a new AI and Data Act. And so this is, and I was smiling when Professor Kaminski was talking because, yeah, this is hard law, but it is going to be soft hard law in the sense that it's the idea is to put in place risk regulation for AI technologies. The law is constrained in part by federalism, by the division of powers, and so it's walking this fine line between what the federal government can do within its jurisdiction and what's outside. And I think that's an interesting question in the context of a technology like artificial intelligence, but that's for another discussion. So it is this risk regulation statute. I had written about it in terms of I called it statutory Mad Libs, because so much of the statute has been left to regulation that you really don't, including the definition of high impact AI, that you really don't know what the law is about. And so I think this is like the softest of hard law in that a lot is being delegated to regulations, and those regulations, I think, in large part are going to be adopting standards, and so which touches on what both Professors Kaminski and Solow-Niederman have said, in terms of the things that we're seeing happening in the space. So it'll be interesting to see what happens with the bill. It's had a lot of criticisms, and then of course on the soft side as well, the oversight and governance of this scheme is very weak, with essentially the minister responsible for AI innovation being responsible for overseeing the regulation, which will largely be driven by corporate compliance with standards and policies and audits that they commission themselves. So it's interesting, and I think it reflects Canada's attempt to to keep up with the EU, to have something on the table, to address issues that might arise around international trade as they emerge. At the EU Act comes into effect, then of course there will be trade issues, and so this is what we've put on the table. So it'll be interesting to see what happens. But in terms of law that you could be proud of, this isn't one of them, I think.
I'll just add, I can't speak to the Canadian side of things. Thank you. That's so fascinating to hear. But I think one theme across every country's challenges is how to address emerging generative models that are more general purpose. And it might be harder to categorize, is this high risk or not high risk? If we're going with a risk-oriented approach, which is where countries seem to be headed for better or worse, it's just hard to figure out the right context, the right lines to draw around that, and what is sensible in a world where we have machine learning models that might be indeed more general purpose, more foundation models. One other just broader point I want to raise is we can certainly think about different hard law or not so hard law approaches in different countries, but there are also other bodies of law that currently regulate AI. And this is a point that Professor Kaminski has made in her work, I should say, with Professor Krutoff and Professor Price, Humans in the Loop, and others. But discrimination law in different countries still applies to AI. Competition law in different countries still applies to AI, and indeed to all technologies. So I think it's important to contextualize different hard law interventions against the backdrop of currently enacted law as well.
I was going to come around a second time just to add to that really briefly. Data privacy and data protection law actually addresses automated systems as well. So just a couple examples of this, and it can be characterized as hard law with a soft touch. So in the Europe's general data protection regulation, you have Article 22, which affords certain individual rights against solely automated systems with significant effects. So a right to explanation, a right to contestation, and a right to express one's voice. And then the California Privacy Rights Act, which is going into effect fairly soon with new regulations to come from the California Privacy Protection Agency, has an anticipated right to have access to information about automated systems and to also have the ability to opt out. And we have no idea yet what that right will actually look like in practice. The reason I say these are softer touch is, at least in the United States, that's not enforceable by a private right of action. It's something that will be enforced by this privacy protection agency.
Yeah, and if I can just jump in on that, I mean, the UK approach, which they've just, they're currently consulting on, has been a little bit different. And they've basically said, look, we already have these regulators. We have an information commissioner, we have competition commissioners, we have, we have a variety of different regulators that already exist. And so our approach is going to be to build capacity within those regulators to deal with AI issues, to set principles and give them a mandate of sorts, to amend the legislation if necessary, which will require study to determine whether they need additional powers or additional scope, and to sort of monitor and oversee the situation to see where the gaps might be, and then to think about filling the gaps. Now that approach has been criticized. All of these approaches have been criticized. That approach has been criticized as well, but it's a different approach. And I think it's interesting because most countries do have a variety of different regulators that will be dealing with bits and pieces of the AI puzzle. But I think it's interesting to think about the extent to which we're actually consciously building capacity within those regulators. So for example, I look at human rights commissions in Canada, and I think they're not resourced or funded to deal with this right now. The governments may talk about, oh, don't worry, you can always make a human rights complaint to the Human Rights Commission, but they're not really talking about the issue of resources, both human and fiscal resources, as well as just capacity to deal with issues that are going to be very complex and very technical. And so I think that this is something that worries me about the ex post part which is, to what extent are we actually paying attention to what we're going to need in order to deliver any kind of justice on, when things go wrong.
Now, I can't resist circling back and chiming in just to amplify. That's such a profound and important point, I think, of what resources do we need, both in terms of technical expertise in the regulatory bodies and just, financial resources to support enforcement and also to support keeping the law updated, so to speak. I think of the FTC here in the United States, vast regulatory remit for both competition law and consumer protection, which is how we tend to regulate privacy, but it ends up touching tremendously on AI. They've issued recent policy statements. There's a planned agenda for the May 18th Open Commission meeting, which will address a potential policy statement on biometric information and Section 5 of the FTC Act. So that certainly bears on AI. And unless we give proper resources to our regulators that we already have, I don't think we can hope to have a coherent governance regime in any nation.
Thank you so much for your answers. That's super, super interesting. And one point that is raised in the essays is this issue of path dependence. Basically, the decisions that we make now will influence the ways we think about these issues and the ways that these structures will work in the future. And maybe I'm kind of wondering, what are some of the kind of foundational normative issues that regulators and advocates outside of government should be thinking about and pushing for as we sort of move towards developing these regulatory systems for AI?
I can jump in, break the awkward silence. No, I know I just spoke, but so I don't know if this qualifies as a normative consideration per se, but I want to flag the importance of leaving play in the joints for these systems. That I think that there can be value in building in space for contestation or reconsideration of principles over time. That design, so Professor Kaminski talked about, human computing interfaces and learning from other disciplinary communities. There's a vast and emerging literature in computing design on the importance of design is longitudinal, reconsideration over time. And so thinking carefully about interventions, opportunities for affected communities to speak up over the process of development, not merely at the outset, and to envision design and development through that lens, I think is valuable.
Yeah, I think that's right. And so, there's a lot of people are talking about, agile regulation that's needed in the AI context because things move so quickly. And I think that one of the real characteristics of agile regulation is that it's meant to be iterative, that it's not, you don't just make regulations and then you're done. You have to be assessing, measuring their impact, measuring their effectiveness, assessing it, and then adjusting and adapting as you go along. And I think that's not something we've necessarily been very good at in the past. And, maybe we've been able to be lazy about it because things haven't moved or changed as quickly as AI technologies are moving and changing. But I think that there's a much more of a need for that. And one of the things that I've been following is at the federal level in Canada, we have a directive on automated decision making, and we've had it now for I'm going to do the math, 4 years, and it was subject to reviews every 6 months and assessments every 6 months. They've now just changed that to every 2 years, sort of 6 months for the initial period. But it's been interesting to see the review and the adapting of the directive over time. And the most recent review has just been published, and they've actually changed they've fixed some loopholes and gaps and improved some things. And so it's been really interesting to watch that process. And I think if we have that kind of, if we're able to have that kind of iterative regulatory process where we go back and we look not just at the AI to see if the model is functioning properly, but at the regulations to see if they are functioning properly. And if we have a good methodology for that, I think that will be very important.
So this isn't from my essay in this particular collection, but I've done work on looking at risk regulation in a bigger context in a longer article. And the thing I'm most afraid about with path dependency is that In the ideal world, what is happening right now, the leaning on impact assessments and on risk mitigation is the step in a longer regulatory process, and we come back and we reevaluate and we tighten the loopholes and we make it better. And in reality, it might be the one bite at the apple. So I worry that starting from a place that is really pretty differential, and I loved the term you used earlier, Professor Scassa, Mad Lib regulation, or Mad Lib laws, but a place that really just leaves a lot of play at the joints, potentially doesn't make for the sort of necessary sword hanging over the head that gets private companies to take these things seriously. My colleague here at Colorado Law has referred to this in the copyright context as a penalty default, and I think we lack a lot of serious penalty defaults in this space. The other thing we might try to do to prevent path dependency from just being path dependency to light touch regulation is to look at sectoral areas where, even in the United States, where there's been more serious consideration given to the risks of AI, because those risks sound in physical harms, health-related harms, or financial-related harms, including systemic financial risk. So one of the things I'm hoping to do over the next year, which is my sabbatical, is take a look a little bit more closely at work on regulating AI in finance and regulating AI in the health sector, regulation by FDA, which Nicholson Price has also written about a good deal, as have others, to try to see, are there some principles about how to have harder light touch regulation that we could bring into some of these more general omnibus approaches to AI.
And I can't resist circling back as well and saying I'm in agreement with you. When I say we need to leave play in the joints, I mean play in the joints for wholesale reconsideration of whether the approach is even the right one in the first instance. I think there is a very difficult line to walk between leaving openness and space for updating and failing to set firm enough initial steps that will fend off kind of corporate co-optation of the intent of the laws. And I think that is a huge, huge challenge.
Thank you. That's super interesting. And one question that has sort of came to me is a lot of the focus in this discussion just now was on corporate uses of AI. I was wondering if maybe you could speak a little bit to the differences between regulating AI uses by like private parties and large corporations as compared to like when the US government uses AI, which they've started to do in certain contexts, and I think raises some interesting questions.
I'm trying to just vary who goes first. So it's my own version of light touch panel regulation. Or nudging. So I would say, I'm going to give the example not of the US federal government, but of a state government law. So we have this law in Colorado that was passed, I think, around a year ago. And it echoes a law that was also passed in Washington State, which is another jurisdiction to watch. You want to talk about federalism and interesting things happening. Another jurisdiction to watch in terms of their approach to regulating AI systems and regulating data more generally. And the law that passed in Colorado is a biometrics law that effectively uses a risk regulation approach to government agency use of biometric systems, specifically facial recognition. And requires those agencies to go in and conduct these assessments and then go through a series of sort of public accountability meetings before they can actually implement the systems. And they're required to take into consideration the input that they get, both from specific communities that they must go out, seek out and talk to, and from the more general public participation process. So the reason I start with the example, instead of starting at the answer to your question, is that when you look at that law in contrast to, say, NIST's approach or the EU, even the EU AI Act, you see that when we're trying to apply this risk regulation approach to government actors, particularly actors that are law enforcement government actors, but also beyond that, the norms of democratic participation kick up a notch pretty significantly. And so we're able to lean on principles of administrative law, administrative law itself, and various like forms of public participation that have long preceding antecedents within general state and federal law that we don't have when we talk about private actors. So I don't know that that really gives an answer normatively as to whether that will work. But what it does do is it puts a very serious thumb on the scale in the name of public accountability when you have a government actor towards more transparency, more participation, and more accountability that's lacking in a lot of the laws that just go after private corporate organizations.
Want to contribute a different aspect of might be different between a public and a private context, but I think is also important, which is that many of the public sector actors are not developing their own tools. They're relying on procurement through private entities. And I think that does lend a twist. It actually, to my mind, heightens the importance of transparency, the importance of knowing where these tools are coming from, and also touching on a point I raised earlier, the importance of technical capacity within government itself to ensure that we're not outsourcing development of tools that are quite significant in making choices that affect human lives, welfare determinations, and so forth, to contractors who are not going to be accountable necessarily to public norms.
Yeah, I think those are really important issues. I mean, what I would add about the public the context is there are a set of constraints that we already have in place around the public context, and Professor Kaminski has mentioned administrative law, which is a really important one for things like automated decision making. There's also the constitutional protections that are a backstop, a kind of a normative backstop. In the public sector, there are things like freedom of information legislation, which also, provide some means of access to information about what decisions have been made and how they've been made and how they've been functioning and so on. So I think there's a bigger public interest oriented a normative framework around the public sector than there is around the private sector. By contrast, around the private sector, you've got trade secrets and confidential information, and you've got a great deal of protection for the actions and activities of corporations, and so that makes it much more challenging and for citizens to have insight or recourse or to engage with in different ways with corporations. So I think that does make it quite different. And depending on the government and the approach of the government, there may be other accountability measures that are in place around procurement and around other sorts of public engagement and so on. So I do think the framing of the contexts are framed very differently. And it can have a really big impact.
Awesome, thank you. I guess one question that kind of comes up, and maybe I should have started with, would be, there seems to be, based on our conversation and from reading your pieces, a sense that soft touch regulation for corporations isn't going to be very effective at limiting the types of harms that we kind of want to see regulated. And so maybe a question that I have is, well, what are sort of the broader limitations of relying on corporations themselves to make these decisions, or relying on public pressure to sort of push corporate decision-making towards a more responsible direction?
Maybe I'll just jump in because I have the most gray hair of anyone on this call. I've been thinking about this a lot lately because I remember the debates around data protection law back in the first the data protection directive in the EU, which was the first kind of globally impactful directive around data protection or privacy from the EU, and then Canada's own law in 2000 responding to that data protection directive. So I remember these debates and discussions at the time, and the line that we were getting from the private sector was, you can't inhibit innovation. You can't squelch innovation. You've got to let us do our thing, because this is, innovation is the lifeblood of the economy, and all of these sorts of things. And so we ended up, certainly in Canada, with very, very deferential light touch data protection laws, but we did get one. And it's been a much slower process in the United States. And so I look at that whole, and I'm hearing the same arguments and the same rhetoric again now, and I just look at how well we did with data protection, right? It has been I don't know what the right word is. Catastrophic may be an overstatement, but it's been terrible. We did a terrible job. And now we are dealing with, as societies, we are dealing with some of the consequences of this rampant, unlimited, unfettered harvesting of data and use of data for all kinds of different purposes. And we're trying to fix problems now after the fact because we didn't regulate up front. So I look at that experience and I think, you know, it's all very well and good to say we don't want to stifle innovation. And some of this innovation is going to be useful and helpful and positive. But some of it, and we're already seeing it, is going to be extremely harmful and detrimental to society and to our well-being. And so we have to, you know, we have to do a better job than we did with data protection. We have to be, I think governments have to be bold enough to set parameters and set limits in a way that wasn't done with data protection, and you know, and find ways not to stifle innovation, but to channel it in more positive, human positive directions and environmentally positive directions too.
I was just going to say something brief, which is that we have this innovation speak, we have the innovation trope. I completely agree. That gets brought up in any one of these conversations. What's really interesting is looking comparatively, not necessarily across countries, but that's helpful too, but looking comparatively into different subject matter areas and when innovation loses and when other things matter more. So there's this excellent book I just want to recommend that's by David Vogel at Berkeley called The Politics of Precaution, where he talks about the ways in which the US and the European Union have actually traded off in terms of just how precautionary they will be about the implementation of particular technologies, looking at risks to health, to safety, and to environmental harms. And so, you know, when you look at it, it makes you feel a little bit less like there has to be this argument. We have to just be replaying this argument over and over again. If we can start talking about harms in different ways, which I think we're already starting to do pretty meaningfully, then there need not be this constant deference to a vague thing that nobody can define called innovation.
Yeah, it's funny. This is the most polite panel I think I've ever been on. I mean, that is a high compliment. I feel like we're all just sort of agreeing with one another, but it's lovely. Yeah, I had my immediate thought on this question was, I want to resist this innovation versus regulation trope. It seems too simplistic to me, and it seems to be unhelpful because I think it leads to regurgitating the same arguments over and over again. One thing I'll add too, I mean, I just saw earlier this week, someone, I believe it was Microsoft, saying, you know, we can regulate AI when we see evidence of its harms. And I went, what? That's patently absurd. So I think just ceding the ground and failing to reckon with the harms that are emerging and have been emerging for quite some time here and now is not the path we ought to pursue. And I'll note too that that's really relies on activists and the affected populations to themselves raise the alarm and get public attention to these matters, rather than engaging in democratic deliberation in the first instance about the kind of society we want to create for all of us.
Thank you for those responses. Here's hoping the government will act with boldness, as Professor Scassa recommended. I'm going to take a couple questions now, I think, from the chat. The first question, do you think standards on training data are sufficient enough to counter the black box effect in AI? How do you think that right to access and explanation will manifest in practice, considering these technical characteristics? From Juliana Sirkin.
I can give again, maybe one level up answer to this. You know, when we think about transparency and accountability with algorithmic systems, you really have to be asking a question of what you need transparency for and to whom the transparency is going. So in the work that I've done on the right to explanation, for example, you have to understand the right to explanation as being something that is information being communicated to an affected individual, a person affected by a significant decision made by an artificially intelligent system. And you need to give that person enough information that they can act on that And you need to understand what is it you want to enable them to do. So if you're trying to let a person opt out of the effects of a decision, you need to give them enough information and relevant enough information that they can potentially invoke that right. That's very different from the kind of information you'd be giving to a third party auditor. It's very different from the kind of information you'd be giving to some sort of expert oversight, say from a regulatory agency, which might get much deeper, more technical and ongoing visibility into your system. So I hope that's helpful.
Also, next question from Rasul Paladov. Hello. So do we have some prospect to establish something like an international covenant to protect sufficient security for the so-called digital sovereignty?
I'm not sure that that at the international level, any movement will be towards preserving digital sovereignty per se. I think that if we have if we start to develop international norms around certain themes or issues in AI governance, it'll be to limit. So it will have a limiting effect on national sovereignty in the way that many of these instruments do, by saying certain things are out of bounds or certain things are off limits, or by saying, all nations must conform to these particular principles or rules. And so it will be limiting of sovereignty in that sense. And so I think that's the tension between the national and the international level. And that's always the challenge of finding the consensus at the international level on norms, principles, approaches that everybody can agree with and everybody is willing to agree with. And I think that this is going to be particularly a challenge in this space where at the same time that countries are acknowledging and thinking about how to address the risks of AI, they are also looking at their competitiveness and their innovative capacity in AI and what they need to do in order to ramp that up to play a dominant role in the AI economy. So I think that probably puts any kind of international norm setting off for the distant future, I would say at this point.
Thank you, Professor. This next question is from Louis Kangider. At my initial reading, the EU AI law really seems to refer to automated decision-making systems. It seems like most discussions today are focused around generative AI models and intelligent analytical systems. What kind of regulatory groundwork should we be laying for the eventual future result of superintelligent artificial intelligence, i.e. true artificial general intelligence? Are there AI rights considerations around consciousness, freedom that we need to put into regulatory thought processes now?
I can talk to the AI rights thing for a second and leave my two colleagues to think about that first question of general versus specific. So there's one interesting take on the AI rights question, comes from Kate Darling at MIT, who says we need to be thinking about whether to afford rights to these systems for a similar reason that we talk about affording protections to animals that are being mistreated by human beings. And the idea is that what rights we give to these systems says more about us as humans than it does about the existential nature of these artifacts as entities. I have another take on it too, which is that when we talk about rights, at least thinking about this within US constitutional law and also US IP law, we really talk about what is it that the Congress or the US Supreme Court are thinking about. What are they trying to achieve when they afford different entities' rights or different individuals' rights? So for example, and some of the answers to this might surprise you when you start talking about whether AI will end up with rights. So for the example, the United States in general takes a much more utilitarian approach to intellectual property law, where it's trying to ask the question, not does an individual need to have their creative works protected because they're in some way entangled with that person's personality and their dignity, but does a person or an entity or a corporation or an AI need to be rewarded monetarily to incentivize them to produce some kind of creative work? And so when you use a utilitarian framing, the answer is much less human-oriented as to whether a right should be afforded than when you use, say, a moral rights or a dignitary framing. That's just one example. And I know that's not the sort of technical legal answer you might be looking for, but I guess this is reflecting some of the work of Jack Balkin in Law and Technology that says what these questions tell us is often more about interesting aspects of the law itself, or what they make interesting things salient about the law, rather than really telling us very much about what we think the nature of the technology itself is.
I think that's how I tend to come at this question as well. So thank you for that intervention, Professor Kaminski. I think that we can't address this or think about the future path of the law without going back to our first principles and the underlying objectives in the first instance. The technology tends to put those latent considerations into especially stark relief. So if we want to think about the kind of laws we want, the kind of regulatory frameworks we want, we have to interrogate the rationale for our rights, for our protections in the first instance, and then engineer from there.
Yeah, and I agree. I think those are both great answers. And I have a much intellectually smaller contribution to make with respect to the first part of the question, just the distinction that's being made there between automated decision systems and generative AI. I've been thinking lately about the intersection between automated decision systems and generative AI. And I think for me, that's quite interesting. Certainly when I look at frameworks that talk about decisions that are either made by AI or that are assisted. And I find that assisted part to be really interesting. Before this session, our moderator sent us a link to a news story about AI translation, which was having an impact on refugee decision making. And to me, that's the interesting intersection. And we do talk a lot about automated decision making. And we have this generative AI that is now generating text, reports, studies, translations, simultaneous interpretation, all sorts of tools which are being absorbed and used by decision makers in a variety of different contexts, whether human or otherwise. And I think that this really broadens the scope of AI-assisted decision-making and the concept of AI-assisted decision-making, because I think somebody who reads a report that's generated by ChatGPT before, sitting on the bench of a tribunal to make a decision is making an AI-assisted decision for which there's now governance. So I'm just kind of looking in at a smaller picture, but I do think that there are going to be some interesting intersections between how we govern automated decision-making and what role generative AI plays in all of the ways in which those decisions may be assisted by generative AI. And I think, anyway, it's something that I'm watching and I think is quite interesting.
I'm chuckling because I've had a number of conversations around how we define these things in the first instance. When we say algorithm, which is a terribly vague term, what do we mean by algorithm? What is in scope and what is not in scope? And these sound like nitpicky legal questions, but they're tremendously important. For instance, if you file a FOIA request seeking information on how governments are using algorithms, what is covered, what is not? And so that's, I think, a very important, subtle point.
Thanks. I hate to cut this off because it's a fascinating conversation, but we're just about at time. So I'll take a moment to thank our fantastic panelists and our fantastic moderator. We hope you will join us for the second webinar in our series entitled The International Scramble for AI Standards, which will be on May 16th at 9 a.m. Pacific time, 12 p.m. Eastern. And that's going to feature Fanny Hidvegi and Daniel Loeffler from Access Now, Vidushi Marta from Article 19, as well as myself. And our final webinar on AI and the First Amendment will take place on May 25th at noon Pacific time, featuring Eugene Volokh of UCLA, Mark Lemley of Stanford, James Grimmelman of Cornell, and Jane Van Bauer of the University of Arizona. You can also look forward to the publication of our essay series, which we expect to take place starting in June. And for any of you who are attending RightsCon next month, we'll also be hosting a satellite event there aimed at broadening our conversation out even further. Thanks again to our speakers, and thanks again to all of you for joining us, and have a great rest of your day.